SJC-12638, Commonwealth v. Alexander E. Rodriguez.
No.
Yeah. Yeah, thanks. Thanks.
Mr. Rappaport, good morning.
Good morning. If it please the court, Stephen Rappaport for Alexander Rodriguez. Giving effect to all the words of the particular statute in this case, I submit that the sentence that was imposed by the Superior Court on Mr. Rodriguez was a legal sentence. That sentence was 1 to 2.5 years on the 10M violation, and the 10M violation in this case specifically was possession of a large capacity feeding device.
Before we go too much further into it, can you just tell me, in your research on this, have you found any difference between a minimum mandatory and a minimum term?
Absolutely.
Explain
Commonwealth
it.
versus Hines, for instance, is a perfect example where you have a minimum term of not less than 5 years. However, this court said that because there was no description of that mandatory language in that case, it did not do away with judicial discretion in sentencing. So while one must get a sentence of not less than 5 years, 5 years, one could easily get a 2 to 5 or a 3 to 5 or a 4 to 5, and that would still be in keeping with a sentence of not less than 5 years. If you look at 279-24, that basically sets the sentence. The upper number is the sentence that you are receiving. So in this case, when you look at the first sentence of 10M, what the court is saying is you must receive a sentence of at least 2.5 years. Well, the defendant in this case did receive a sentence of 2.5 years. The bottom number, the 1 year, if he's lucky, there may be some deductions that he might get and perhaps be eligible for parole, not in this case, but he might be eligible for parole after 12 months, after a year. Certainly he'd be eligible for starting to receive deductions on his sentence. When you look at the first paragraph, and it says, not more than 10, we know that the max now is 10, not less than 2.5. If there had been no sentence number 3, it might be a little bit clearer in the sense of, let's say, an 18C, where the court had said at one point that it was not less than 20 or up to life, and that set the minimum and the maximum in that case. But you don't have that non-reducible language that you have in this case in sentence number 3, which specifically states that you cannot reduce this sentence to less than 1 year,
So
not
are you
less
saying,
than 2.5 years.
Are you saying that the first sentence means that not less than 2.5 means the high number can't be less than
Yes.
2.5?
Yes, precisely. Just as in Hines, which that would be the case, or even in Lightfoot. Lightfoot, 277.7, I believe the penalty provision there says that upon conviction, you will receive a sentence of 5 years. It then goes on to have that mandatory minimum language similar to what we have in this case, that under no circumstances is a person to serve less than 2 years of that sentence. The court interpreted that to mean that a 2 to 5 is an appropriate sentence in that case, despite the fact that the language says you're going to have imposed upon you a 5-year sentence. So the top number is the sentence that is being imposed. The bottom number is your hope that if things work out for you, if you get earn good conduct deductions or earn other types of deductions, you have a hope of getting out in less time. But your sentence is still that top number. That's the sentence. If you don't get those deductions, if none of those contingencies come through, that's the sentence you're going to be serving. And that is the sentence that you're given. The top number is the sentence.
To Rappaport, as far as just the overall scheme, and I know our case law has been less than clear on whether or not magic words are necessary to get you the minimum mandatory. So if someone violates the statute and they have an FID card, so now we're talking about the second sentence, right?
If they have an FID
No,
card, no mandatory sentence
At
will
all.
apply at all.
Okay, I think that's clear because it says no. But what's the penalty for someone who has an FID card? As I read it, it's 2.5 to 10, but you could be put on probation.
Yes, it could be 2.5 to 10. It
Less
could
than
be
2.5.
It could be straight probation. Let's assume
What
for a
about a
moment
year?
he had an FID card. The judge could have given him this and gave him the same sentence that he gave him. What that would mean is that from the day he started his sentence, he would be eligible to earn good conduct deductions. There would be no mandatory minimum sentence.
In your view, if someone's arrested and they have, for this crime and convicted, and they have an FID card, could they get a 6-month in the House of Corrections sentence?
I would submit no.
It has
I
to.
would submit that.
So if they're going to get a sentence, so if they're going to get a sentence, what's the minimum they could get?
You have to get a state prison sentence. That's part of, when you look at the concurring opinion in Semigen, the concern with the concurrence there is, hey, wait a minute, we've got this framework here, and if we have a lesser sentence.
And I messed up. You're absolutely right. There's no House of Corrections alternative.
So, but
could they get 1-to-1 in a day if they had an FID card?
No, because you're not, you could get if you were committed, you would have to get a 2.5-year sentence. It wouldn't be a mandatory minimum, though. The difference between a minimum sentence and a mandatory minimum sentence is that on a minimum sentence, you can earn. So if that person with the FID card would have, let's say the smallest sentence he could get is 1 to 2.5. The difference between him and Mr. Rodriguez is from the day he goes in, because he's not subject to the mandatory minimum, he's earning, if he is, good time deductions from his sentence. He can work and earn credits from his sentence. From day one, Mr. Rodriguez, in his situation, because of this 1 year, you may not reduce, you may not get any credit. Because of that, he's not earning anything during his first year. So he has to serve at least that first year. Under the sentence that the Commonwealth says is the minimum sentence, the 2.5, he wouldn't be, that's 30 months, he wouldn't be eligible for anything for 15 months. It would be impossible to be released at 1 year, even if you look at, I think the Commonwealth throws out the furlough at one point and says, well, it's not, sentence 3 is not totally superfluous because there are furlough provisions that, no, do the math. If you're entitled to furlough at the 1/2 mark to your lower number, and the Commonwealth is correct that the lower number has to be 2.5, that means that half of 30 months is 15 months. You still can't get a furlough at 1 year. So sentence 3 is, if the Commonwealth's interpretation is correct, it's not only mean, it is absolutely superfluous. There's absolutely no reason for it to be there.
Isn't your better argument, because you can say the same thing about the third sentence, isn't the better argument is that sentence, and I understand you're saying the 2.5 means the maximum, which is hard to read when you read that first sentence, and we don't have any other statute that would be read that way. But you read the first sentence, you read the third sentence, you can't possibly reconcile the two, and the rule of lenity applies.
Well, I would submit to this court that the rule of lenity, if you disagree with me that it's clear, I submit, and the defendant submits in this case, it's clear that the three sentences are harmonized.
You might be the only one that thinks it's clear,
Yeah.
Mr.
Well,
Rappaport.
when I say clear,
That might be you.
I've written a brief. Not a lot of people have written briefs. So, but when I say it, yeah, it starts to appear clear to me. Yes, whether that's fortunate or
Maybe I'll get you. I
unfortunate.
don't know, but
I don't.
we'll see.
And you know me, so I see things sometimes. But I was going to say to this court, I believe that Your Honor, you were on the Lindsay panel that.
It's her
I
fault.
have no, yeah, it's my fault.
No, well, I looked and
No,
see,
I have
and
no
I saw
memory
you
of
were on
that.
the
I
Lindsay
mean-
panel, which came down the same day as Semigen. And what Lindsay says is, look, if we were writing on a blank slate, we might agree, but we've got Semigen.
Right.
The problem with Semigen just ignores the fact of any language having to do with a person not having
Well-
a.
Just so you know, she was the panel chief on that one.
Okay. He's blaming me for everything.
May
I have a way to read this, I think, that makes sense to me, maybe to no one else, but that any such person in the third sentence refers to such person in the second sentence.
That's what the Miller Court, there was an unpublished opinion
Right.
many years ago, and that's what the Miller Court said. But if you look at that, it doesn't make sense, because sentence number 2 says, under no circumstances will anybody who has an FID card be subject to a mandatory minimum sentence.
That's where we get, when you continue with this sentence, it's talking about not reduced to less than 1 year. It's not saying it's a minimum mandatory 1 year.
Oh, yes, it is. That is the language.
That's-
Judge, I
That's what I'm.
respectfully
that's where-
disagree.
Okay,
Um,
that's the
I would
problem then,
submit,
isn't it?
I would submit to the court that the language used in sentence number 3 is very, it's a common format that we use often in setting mandatory minimum sentences.
so such
A sentence that may not be reduced below.
So
is-
such person skips to sentence number 1.
It goes
and they-
back to
and
number
they-
1.
and they pause to say, if you get an FID card, it's not a defense, but you're not going to jail.
Well, or you don't have to.
Or you
go
don't have to
to
go to
jail.
jail,
I mean, everything depends upon the facts of the case, and I want to.
Can I follow up on that just, and,
Certainly.
because I share Justice Cypher's interpretation, but I don't, I'll be honest, I don't understand this provision. But they use any person in the first sentence, and then they shift to such person for the rest of it. Does,
I think
Doesn't-
such person tends to refer back to the first sentence, where they say any person, and then they say such person meaning that person, and then such person meaning
Really?
that person. I think.
really? Because it looks.
As I
because-
read it,
Can
Judge-
I just ask, and again, you're way ahead of me, and if it's clear to you, you're 3 steps ahead of me, but.
I may have a problem
It says,
if it's clear to me.
it just goes, any person is the first sentence. Then the second sentence talks about the FID card, and that, until it gets to the semicolon, provided, however, that any such person shouldn't we refer that to the first clause before the semicolon, the possession of a valid firearm? So provided, however, that any such person charged with violating this paragraph and holding a valid firearm shall not be subject to any mandatory minimum. I mean, I get the inconsistency, but that the 1 year is also a mandatory minimum.
Well, the 1 year is, without a doubt, a mandatory minimum.
Okay.
The question is the two, and that's what we hear about, is the 2.5 a mandatory minimum, or is it merely a minimum sentence that must be imposed, similar to that in the Hines case, where the court said not less than does not take away all judicial discretion in fashioning a sentence. And I do want to state that the concurrence in Semigen was
That's
concerned
Justice
with the
Green's
overall
Is that
format.
Justice Green's opinion you're talking about?
Yes. And what I'll say to you is, first of all, the notwithstanding language that begins the first sentence means that in addition to. So we're not talking about a statute that is in lieu of. It's not either or. You can get both, depending upon the facts of the case. You can be sentenced under both. And in this particular case, where the defendant was charged with carrying a firearm and possession of a large capacity feeding device, those are not, you could receive a consecutive sentence very easily on that. One's not a lesser included of the other. The statute 10M provides for a potential 10-year penalty. The mere possession of a firearm only has a house maximum of 2 years, and no man-min of any type. Carrying, while it does carry a larger man-min, it carries a shorter maximum sentence. And when you look at what's being punished, in the case of 10M, you're talking about mere possession. If I have constructive possession over my sock drawer and the items in my sock drawer, and I have an empty clip in my sock drawer, I can be charged with 10M. Somehow, I don't view that as inherently dangerous as me walking around with a
yeah, but,
loaded
you know,
345.
Yeah, but when we look at what the legislature has done, and we look at all the tragedies that are that are occasioned by people with large clips all over the country, and we talk about our gun laws. So legitimately, the legislature could be saying, we don't want these large capacity weapons because of all these mass shootings in Massachusetts. We're going to put teeth into it. That's why it gets all the way up to 10 years.
Exactly, and here's the teeth. You can get 10 years in addition to what you get for carrying a firearm. And you can get an aggregated 3.5 mandatory minimum sentence.
Yeah, but you're still saying, with your interpretation, that if you've got one indictment and you've got a large capacity loaded firearm, that the sentence could be less than just carrying a firearm.
It could be.
Which
And-
absolutely makes no sense.
Well, no, that's not so, Judge, because we do have to look at the circumstances of each case and the circumstances of each defendant. And Superior Court judges are actually put in that position where they have to make discretionary determinations as to what a sentence should be. If you have a particular individual who is not particularly saleable to the court, you can give him a 9 to 10 for the large capacity weapon. Apparently, as the Commonwealth did in this case, you can charge for the carrying the weapon if it's outside, if it's not in your home or business, as well as charge for the large capacity feeding device, which the weapon is going to have. So as I say, in this case, the Commonwealth indicted in this case so that if they had an individual who was a particularly tough sell to the court as to, let's give the guy a break, a court could have given him from and after time very easily on this. They are not lesser included offenses. And it's how the Commonwealth chose to charge him, as they can do in any case where the Commonwealth believes, for some reason, that the person deserves to have a sentence of more than 5 years and a mandatory minimum, perhaps, of more than 2.5 years. The Commonwealth has that option. It's how the Commonwealth charges. They take out the thesaurus and they come through their various crimes. And here's a perfect example, Judge, because this should have been charged as a large capacity weapon, because when Mr. Rodriguez was arrested, in his car, he had a loaded 12-shot semi-automatic. That's a large capacity weapon. The Commonwealth chose not to indict him on the large capacity weapon, but only on the feeding device. Hence, you don't have a lesser included, and you can get one sentence added to the other sentence, if it was the appropriate case.
One last question from me, and that is whether any of the general laws regarding the sentencing guidelines have any application to this in terms of permitting a judge to deviate.
I don't believe that a judge can go below, I could be wrong, but I thought that when there's a mandatory minimum sentence, I don't believe the judge can deviate below that 1 year. With a minimum sentence, I submit that Hines stands for the proposition that a minimum sentence does not destroy judicial discretion in sentencing, that it remains.
Can I just ask one? Sure. What's the status of the defendant right now? Is he in custody?
It's interesting, Judge, because he was sentenced on January 5th. If Judge Billings and counsel are correct, he would be immediately eligible for parole. But as it is, the DOC has taken the position that they're not going to do anything until this case is decided. And it's very interesting. As of 14 months ago, the DOC was still sending letters to the Superior Court clerk's office saying that 2 to 5s and 3 to 5s under Hines were illegal. So the fact that the DOC says it's illegal, I don't, there are lawyers working for the DOC who do the best they can with these statutes, as we all do. But depending upon what happens in this case, my client would be eligible for parole.
All right, thank you. Mr. Blatchford.
Good morning. May it please the court. Howard Blatchford, Assistant District Attorney, Middlesex County, on behalf of the Commonwealth. The statute's clear to me as well. It wasn't at first. It's complex. It requires a few readings and may not be apparent on the first or second or third reading, but eventually it seems to make sense. There are 3 components to the statute. The first sentence clearly sets the sentence for a violation of the statute at a term of 2.5 to 10 years. The second sentence then pivots to a situation involving a person with a firearms ID card. That issue is not in play here because there's no suggestion that Mr. Rodriguez had a firearms ID card. We then get to the third sentence, which really doesn't deal with the term of the sentence at all, but rather with the execution of the sentence that's imposed under sentence 1.
How do you get around the minimum mandatory language in Hines, the not less than?
Hines, as well as Lightfoot and Birdie, which the appeals court cited in the case that was decided the same day as Semigen, all had the same problem that's not apparent in this case here. Hines, Lightfoot, and Birdie all involved a statute in which there was no indeterminate sentence. It was a sentence, the only sentence that was available was one for a set term of years. And the court, I think, struggled in each of those three cases to make the sentence compliant with the statute that had been enacted in the 1990s requiring indeterminate sentences to state prison. And they reached down to the floor that was established in the third sentence that we have here in 10M, which appeared in the statutes in each of those other cases, and set that as the floor to create the indeterminate sentence.
Do you think that such person in sentence 3 refers to the person in sentence 1?
I believe that it does. And that once the sentence is imposed under sentence 1, then the sentence reduction language in terms in the third sentence come into play. And there are three components to that. The sentence imposed upon such person shall not be reduced to less than 1 year, nor suspended. And third, nor shall any person convicted under this subsection be eligible for probation, parole, furlough, work release, etc., until he have served such a minimum term of 1 year.
So
Go ahead.
if you get a 2.5 mandatory minimum, on what situation, let's say it's not a mandatory minimum, it's 2.5 is the minimum that you can have imposed. So you get a 2.5 to 6. Under what circumstances would you ever be eligible to be released any sooner than 1 year, or even at 1 year?
I believe that there's at least a theoretical possibility under the furlough provisions. I did a calculation on this, and if we start off assuming that someone is sentenced for 2.5 years, and their parole eligibility would ordinarily be 30 months less any credits they received for good conduct or educational credits, so-called completion credits under 127, 129D, they could earn up to 15 days per month of good time and an additional 10 days in a month in which they completed a program or course or whatever, work that was permitted by the Department of Correction. At the end of 9 months, a defendant would have earned at least 225 days under that theoretical scenario. It assumes, of course, that good conduct does occur and that these programs are available and they complete them. 30 months, the 2.5 years, less the 225 days, which is 7.5 months, is 22.5 months, and 50% of that, which would be the furlough eligibility, brings us down to 11.25 months. In other words, 11 months in 1 week.
See, my challenge there is, and I could be wrong, is that when this legislation was being voted on, that when that third sentence was written, none of the legislators came up with that idea or did that math where, boy, if you really thread the needle and you look at possible earned good time and possible best-case scenario furlough, you might get under a year. It seems probably what might have happened here is not a recognition at that particular moment that state prison sentences can't be suspended, in part.
I think that's possibly true. This language goes back at least as far as 1974, to the third sentence.
Right, and in 1974, you could have a suspended state prison sentence.
Understood.
And that's probably how you make sense of this legislation.
And that brings me back to one of my questions earlier about the sentencing guideline law, which is still on the books, I believe, in 211E, Section 3, talking about except in one circumstance, Chapter 265, any other case where there's a minimum mandatory, if the judge is following the guidelines, and I know we haven't adopted them, but the reasoning was that they would be permitted to deviate below that minimum mandatory. And that makes me wonder, perhaps, is that why that last sentence is in this paragraph?
Well, I think this last sentence, as I just noted, dates back 4 decades at least. So
okay.
it probably wasn't the legislative
But it
intent at
wasn't-
that time. But it could also be that the legislature recognized that these things change over time, that all the time the CMR changes, the regulations and the statutes have changed concerning the amount of good time that can be earned, educational credit time, and so on and so forth. In fact, in the Criminal Justice Reform Bill of last year, there were provisions that changed these that went into effect last month, raising the amount of good time that could be earned from 7.5 days up to 15. So I think that it could be fairly said that there's legislative recognition that these factors change over time, and they want to set a floor below which it's not going to, a sentence
Let
would
me
not
ask you
fall.
one more question about this last sentence. If we read it your way, what use is the language "such person" or "upon such person"? Why wouldn't they have just written, "The sentence imposed in this section shall not be reduced to less than 1 year"? Why did they have to put any such person in at all?
I suppose it could have been written that way. The fact that it was written this way doesn't make it ambiguous for purposes of determining the minimum sentence in this case, I would suggest.
The problem with your arguments, among others, is that the sentence doesn't change. The judge imposed the sentence. You're referring to the time served. But
Correct.
that's a decision by the executive with regard to, it doesn't say the time served shall not be reduced. It says the sentence imposed shall not be reduced. So how do you say that that was meant to refer to differences in terms of time served, which is addressed in the latter part of that sentence?
Well, I think there are 3 separate components to that sentence. The first part is that the sentence imposed upon such person shall not be reduced, so the sentence stays in place. And as Your Honor pointed out, many of the functions, if you will, in the last clause, the 3rd clause of this sentence, do in fact deal with executive branch functions in terms of reducing the amount of time that will be served. And this appears to me to be a legislative intent that the person convicted and imprisoned shall not be able to get his sentence, the time served, such minimum term as is used in the very last end of that sentence, below 1 year.
Right, which is what your brother says. That's the classic language of the minimum mandatory. Was there at any point in time when the statute was first enacted the capacity to do a split sentence in a DOC sentence?
I don't believe so. This statute, 10M, was enacted in 1998 as part of an overhaul of 265 and Chapter 140 firearms as well. And I believe that the split sentence issue was decided before then.
1994.
So there was no capacity to do a split prison sentence.
Apparently so.
So if the sentence shall not be reduced to less than 1 year, does that not also mean that the sentence may be reduced to 1 year?
That the time served, that the minimum term of such sentence can be reduced pursuant to this last 3rd clause. That's my reading of that.
I'm sorry, I don't get it. Does it not mean that it may be, that the sentence which is set by the judge may be reduced to 1 year, but not to less than 1 year?
Not below 1 year.
Right, so if it says you can't go below 1 year, does that not implicitly say you may go to 1 year?
I believe that's what it says, yes. 1 year in terms of the execution of the sentence once the 2.5-year minimum has been imposed.
Okay, but you're thinking of a sentence in terms of time served as opposed to the actual sentence.
That's right.
You agree that Mr. Rappaport is correct, that if you get a 1 to 2.5 year sentence, you are in the custody of DOC for 2.5 years. You may be on parole for one part of it, but you're in the custody of DOC.
Well, I wouldn't agree that you could get a 1 to 2.5 year sentence under this statute, under 10M.
I understand, but put aside that. Do you agree that you are under the custody of DOC for 2.5 years if you get a 1 to 2.5 year sentence?
I think that depends upon how you would define the word custody in that circumstance. I assume that you're referring to someone who has been paroled.
Right. If you're unparoled, you're still within the realm of
Technically
the
not in custody.
executive.
I mean, you're not technically in the custody of the Department of Corrections.
Well, but they
You've been
can,
released.
the executive, without coming to a court, can revoke your parole and put you back. Parole means we will allow you to serve the balance of your sentence on the street, provided you engaged in good behavior, correct?
Correct.
So,
But not physically in custody of
Well, I
the Department of
understand. I
Corrections. And I guess
understand.
that's my distinction I'm trying to draw.
Okay.
so if sentence 1 and section 3 are just going to be at war with each other, why doesn't the rule of lenity just break the tie here?
Because the reported question, I believe, can be fully answered by the first sentence of Section
But
10F.
don't you have to scratch out the third sentence?
Well, I believe that the court in Semigen reconciled and harmonized all three sentences, in fact. That's the Commonwealth's position on this. But that the reported question can, in fact, be answered by the first sentence, which says the sentence imposed shall be from 2.5 to 10 years. If there were no other questions, the Commonwealth would rest on its brief.
Okay, thank you.